Okay, good morning. My name is Susie Kaufman. I'm a partner in the litigation group. It's my pleasure to welcome you to Goodman's for our program, which we've titled Positioning Yourself for Success in Litigation. I should just note that our original title, and this is a true story, was Weathering the Storm. We must have anticipated the weather this morning, and I think you should all thank us for bringing you in here early to avoid the freezing rain. We are also pleased to welcome over 60 people joining us by webinar. Our panel this morning will discuss various dispute resolution issues and challenges that would typically arise in the context of litigation. Many of our attendees today are in-house counsel or business executives involved in some way in the litigation process. We hope that at the end of this morning's session, you will be better equipped to make decisions that will contribute to a successful resolution of your disputes. And for the rest of you, just here to get your CPD hours, I hope you'll still find our presentation of interest. Before I introduce our panel members, I just want to cover a couple of administrative matters. For any lawyers in the room, this morning's session will be eligible for 90 minutes, 1.5 hours of substantive hours towards your annual CPD requirement. Everyone will receive a proof of attendance email following the session. You can retain that email for audit purposes, and the email will talk you through the process for reporting the session on the Law Society portal. If you have not yet signed our attendance sheet, please do so that we can ensure you receive a copy of this email. And for those of you joining us by webinar, we will send the proof of attendance to the email that you used to sign in. So with these administrative details out of the way, let me introduce our panel members briefly. Beside me to my right is Tamron Jacobson, and Tamron is going to start by walking us through the practical implications of arbitration clauses, when you should or should not be using them, and how to use them effectively. I will follow Tamron's presentation with a high-level overview of how to deal with document preservation, collection, and production when faced with litigation or arbitration proceedings. To my left is Hannah Arthurs. Hannah will discuss confidentiality or sealing orders and explain when those orders can be obtained to protect confidential information from the public record. Next to Hannah is Brad Halfin. Brad's presentation will focus on the settlement of disputes, including when settlement should first be considered, and the cost consequences of settlement offers. And at the far end is Mark Dunn. Mark is going to let us know how to seize assets once you have a judgment. And he has a few interesting war stories to share, so I encourage you to stay to the end. We are all part of the litigation group here at Goodman's. You can read further about our particular expertise and experience in the bios that were sent with the original invite and that will accompany the proof of attendance email that will follow the presentation today. Each of us will speak for about 15 minutes, and we'll pause briefly for questions at the end of each of our presentations with an opportunity as well at the end. And we promise to have you out of here by no later than 9:30. So with that started, I will turn it over to Tamron.
Thanks, Susie. So this session is about positioning yourself for success in litigation, but I'm actually going to spend the next 15 minutes talking about an alternative to litigation, arbitration. And I'm going to spend a brief amount of time refreshing our collective memories about what arbitration is and when parties might agree to go to arbitration. But I'm going to spend most of the time talking about questions you might want to ask yourself when you're drafting or reviewing an arbitration clause. And to focus our discussion, it's helpful to remind ourselves that arbitration is the contracting out of the public civil litigation process by parties, and instead agreeing to privately hire an independent, neutral third party to determine the dispute for the parties. And those parties can agree to go to arbitration either before a dispute arises or after a dispute arises. And given all of the purported benefits of arbitration, you might be surprised to learn that it's actually quite rare for parties to agree to arbitration after a dispute arises. Sometimes the parties' positions are at that point quite polarized. Perhaps one party thinks there might be a strategic advantage to publicly airing the dirty laundry of the other party, or they might not just be able to agree to just about anything at that point. And so the vast majority of arbitration agreements arise before the dispute comes into place and are usually contained in the corporate or commercial documentation that governs the parties' relationships. So, for example, a purchase and sale agreement, a license agreement, shareholder agreement, or the multitude of other agreements that can govern corporate relationships. But because the arbitration agreement usually arises before a dispute exists, and indeed usually when parties are trying to rush to get a deal done, oftentimes people don't spend a lot of time looking at and thinking about their dispute resolution provision in their contract. Some of you may have precedent agreements that your organizations use with customers or suppliers or a whole bunch of other people, and I bet there's at least a couple of you, perhaps without admitting, that haven't looked at the dispute resolution provision in those agreements probably since the precedents were drafted, if at all. And so if we go back to high-level first principles, when do parties typically think about agreeing to arbitration, or when should they think about agreeing to arbitration? Perhaps you have an ongoing commercial relationship and you'd like a way of dealing with disputes as they arise and then moving on from those disputes. Perhaps you want the potential for a quicker and more efficient resolution with limited or no rights of appeal. Maybe you want privacy and confidentiality. Perhaps you want a decision maker with a particular set of expertise. Or maybe the two parties are from different jurisdictions and neither party wants to submit to the courts of the other party's jurisdiction. All of these reasons are good reasons for entering into arbitration, but none of them are guaranteed or automatic simply because you agree to arbitration. And their successful implementation in large part depends upon the proper drafting of an arbitration clause, and it also depends in large part on the personality of both the arbitrator that you choose as well as the counsel that you choose and the other party chooses, and their willingness to depart from traditional litigation methods where it's appropriate to do so. Before we get into the nitty-gritty of what to put in an arbitration provision, I want to very briefly set out the statutory framework for arbitration in Ontario. If the place of a commercial arbitration is within Ontario, there's one of two statutes that can apply. The first is the International Commercial Arbitration Act, which typically governs when there are two parties from different countries, but it also can apply where you have two parties from the same country and a substantial part of the obligations under that agreement relate to a different country. So, for example, you might have two U.S. companies where the contract is about work that's going to be performed in Ontario, and the arbitration is going to take place in Ontario. The domestic arbitration in Ontario is governed by the Arbitration Act 1991, and it's easy. It says it applies to all arbitrations that are not international commercial arbitrations. Both the international and the domestic statutes set out a set of default rules that govern things like jurisdiction and composition of the arbitral tribunal, procedure for the arbitration, enforcement rights, court intervention rights, and rights of appeal. And in large part, some of the statutes deal with those things in the same but somewhat different ways. The two biggest differences between the statutes are the number of arbitrators, or the default number of arbitrators. Under the Domestic Act, the default is 1. Under the International Act, the default is 3. And the other major difference is the defaults for the rights of appeal. So under the International Act, there is no appeal of an arbitration award. And under the Domestic Act, the default is an appeal on a question of law with leave if you meet certain criteria that the court finds acceptable. So the parties, if they write, we agree to arbitrate all disputes, there will be a set of default rules that you fall under, and that one sentence constitutes an arbitration agreement, and there will be a set of default rules that you'll fall under. But although the statutes set out default rules, since arbitration is all about the agreement of the parties can contract out of almost all of the provisions of the acts with some limited exceptions. So if we're thinking about what to contract into or out of, when I'm looking at an arbitration provision, I typically ask myself 5 questions. What, when, who, where, and how. And each of these questions has multiple sub-issues. Given my limited time with you, I'm not going to talk about multiple sub-issues, but I will raise 1 or 2 issues within each question that you can think about when looking at an arbitration provision. The what is, in some senses, the most important question, and it's what is your scope of arbitration? How wide or narrow of a jurisdiction have you given the arbitrator? And parties can agree to a very wide scope for arbitration. So, for example, all disputes in any way connected to the commercial relationship. That would be an example of a fairly wide scope, or the parties can agree to an extremely narrow scope for arbitration. So, for example, in a purchase and sale agreement, the parties might agree that any dispute related to the calculation of the purchase price adjustment goes to arbitration, whereas all other disputes go to litigation. And the only thing I'll say about being somewhat wary of narrow clauses is they're definitely fine, but it can in some cases lead to a bifurcation of disputes between arbitration and litigation, where you have a number of issues, some of which are arbitrable and others are not. The when of arbitration that I'm going to talk about deals with preconditions to arbitration. I'm sure you have all seen agreements where there is a contractual requirement to have a series of meetings with progressively senior employees to negotiate in good faith a resolution. If those aren't successful, sometimes there's a requirement for mediation, and if that's not successful, the parties will be entitled to commence an arbitration. I have seen those types of clauses work quite effectively in contracts that are dealing with projects of long duration, where there's a number of anticipated disputes that are anticipated to arise. So, for example, a large construction project or a major technology implementation project, sometimes it's quite helpful to have the people who are actually working on the project meet at first instance to try and resolve a number of disputes that arise. But when you're dealing with large and complex disputes, and in particularly situations which are more one-off type transactions or one-off disputes, I find that the preconditions to mediation, parties often end up just going through the motions and to fulfill their contractual obligations, which can end up delaying the commencement of the arbitration. Usually that's not much of an issue, other than being a little bit of a waste of time, but it can end up being a significant issue if you're coming up against a limitation period, because courts have said that you need to fulfill all of the preconditions to arbitration before you actually commence an arbitration. And of course, as Brad is going to talk about later in the program, even without a contractual requirement, the parties are of course free to agree to halt the litigation process at any time and try and negotiate a resolution. The who of arbitration typically deals with one I've already talked about, the number of arbitrators, 1 versus 3. The benefit of one arbitrator is, of course, it's going to have some significant cost savings. It also leads to a much easier time coordinating, particularly if you're dealing with 3 well-respected, busy arbitrators who may be booked up months in advance. Obviously, the downside of one arbitrator is that all of your eggs are in one basket. Particularly if you have no rights of appeal, you are stuck with whatever decision that one person makes. With special qualifications, the parties can agree to an arbitrator with whatever qualifications they'd like. They can agree to have an arbitrator who is a certified accountant, an engineer, a retired judge, anything they'd like. And if you're going to put specific qualifications in your arbitration provision, just make sure that you consider the scope of the arbitration clause and the anticipated disputes that might arise. So, for example, a certified accountant would be an excellent arbitrator for a dispute about the calculation of a purchase price adjustment, but you might not want an accountant dealing with your contractual interpretation disputes. The where of arbitration deals with the physical location that the arbitration is going to take place, and it's important because it determines the procedural law that's going to govern your arbitration, which statute you're going to fall under. And that procedural law can be the same as or different from your substantive law under your contract. And the only reason I raise this is before you agree to an arbitration that's outside of Ontario, just make sure that you understand what their statutes say and what the defaults under those statutes are, so that you can know whether or not you want to contract in or out of any particular default under that statute. It's somewhat less of an issue for the international arbitrations. Many countries have adopted the UNCITRAL model law for arbitrations. That's what the Ontario International Statute is based on. But many countries have not, or I should say some countries have not, including a large number of states in the US have not adopted the model law, and their defaults may be somewhat different than the defaults under the model law. Regarding the how of the arbitration, I'm going to talk mostly about procedure. And parties can use an institution to administer their arbitration for them, institutions such as the ICC, the LCIA, JAMS arbitration. There are other acronym-based institutions that you can use. Or the parties can agree not to go through an institution and instead conduct an ad hoc arbitration. If the parties do that, they still have a number of different options for the procedure of the arbitration. They can agree to a set of specific procedural rules. In places like UNCITRAL has a set of arbitration rules. There's the IBA rules of evidence. Or the parties can make up their own procedural rules in as much or as little detail as they'd like. So, for example, the parties can agree that they're going to do full discovery, limited discovery, no discovery. They can set out how the arbitration hearing itself is going to look, whether there's going to be live witnesses or evidence by affidavit, and any, as I said, as much or as little detail as they'd like. The final option is to leave the procedure up to the discretion of the arbitrator at the time the dispute arises. That's the default under the statute. And the only thing I'll say about setting out in advance a very detailed procedure is that it's sometimes difficult to anticipate in advance the type of dispute that's going to arise under your arbitration agreement, and therefore the procedure that's may be appropriate to that particular dispute. And this sort of goes back to something I said in the beginning, which is, in large part, if you have a skilled and experienced arbitrator, he or she will be able to craft a procedure that is most efficient for the particular dispute you have, while also having enough procedure that gives that dispute credit. And that's particularly so if they also have the assistance of experienced arbitration counsel on both sides. The last point I'll make about the procedure is confidentiality, and I would encourage you to not automatically expect that your arbitration is going to be private and confidential. There is some conflicting case law about that, and so if you have an expectation of privacy and confidentiality, it's best to put that right in your arbitration agreement. Also, be sure to carve out any exceptions you might need. For example, if you're a public company, you might have public disclosure obligations, and just make sure there's an exception in your provision for that. And also note that on judicial review or appeal, confidentiality can be lost, although the parties can agree that they will at least cooperate in seeking a sealing order, and Hannah will talk about that a little bit later, and it's not automatic even if the parties agree to that. So there is on your tables, there should be a sample arbitration clause which deals with and puts into more practice some of the issues I've talked about. It also deals with some of the issues that I didn't have time to cover. I intentionally called it a sample arbitration clause and not a precedent arbitration clause. Arbitration clauses really do need to be drafted to be appropriate for any particular situation. And if you take nothing else away from these 15 minutes, I really hope that the next time you enter into an agreement, you just take a moment to look at and think about your dispute resolution provision and determine if it's appropriate for the relationship as well as the anticipated disputes that might arise under that relationship. So I will end there, but I'm happy to take any questions before I pass it over to Susie. Yes? Mm-hmm.
You talked about the procedure and coming up with your own procedure for counsel. In your experience, thank you. In your experience, to what extent, if you don't front end your discussion of the procedure, does it end up looking just like Superior Court? Because that's always a big concern for me.
Yeah. So that is the balance, and it is always the trouble. Of course, if you want the most simplified, guarantee of the most simplified procedure, you might agree in advance to no oral discovery or limited production. But you do run the risk of it becoming not an appropriate amount of procedure for the dispute. I've found in large cases whether counsel can agree depends on, as I said, I wouldn't say the quality of the arbitrator, but the willingness of the arbitrator to depart from traditional litigation methods, and even more importantly, because it's usually you only go to the arbitrator if the counsel can't agree, the willingness of counsel for the parties to agree to something other than a full litigation technique. And I agree with you. Sometimes it's difficult to do that in advance. One of the methods is the best method is ensuring that you have a good arbitrator who is not going to just follow the superior court. But otherwise, you end up with the same procedure, and then you not only is it not as quick, but you're also ending up paying more because you're paying the arbitrator as well as all of your discovery costs. Okay, so I'm going to pass it over to Susie Kaufman, who's going to talk about document preservation and collection.
I think I might have drawn the short straw in terms of topics, so bear with me. I will try to make this as exciting as possible. Before I begin, can I get a sense from those in the room if you've been involved in any significant document preservation, collection, and production process? Okay, so we have a few. So you'll relate to this topic, perhaps, and others may be empathetic towards us. So the Sedona Canada principles are the guiding standard for e-discovery in Canada. They were first introduced in Canada in 2008 and were recently updated, and they're available on the internet if anyone wants to read them. I'm going to touch briefly on three topics: document preservation, document collection, and then document production. So starting with preservation. As soon as your company becomes aware that it may be the subject of litigation or arbitration proceedings, the obligation to preserve documents and ensure that they're not destroyed kicks in. So it's important to realize litigation proceedings don't have to have been commenced. It's the reasonable prospect of litigation that could trigger this requirement. This could be upon the receipt of a demand letter or a complaint, or of course, if your company is the plaintiff or the initiating party to a proceeding, the preservation obligation would be activated or triggered before the litigation proceedings are commenced. And at least initially, the obligation is to preserve in original form all documents that are potentially relevant to a litigation proceeding until such time as determination of relevance and privilege can be made. So just to fast forward to the obvious question, what happens if you don't preserve documents? And the risk is that a court could make a finding of spoliation of evidence, or more likely draw an adverse inference from the lack of available evidence. The bar in Canada is still relatively high, and there have not been findings of spoliation of evidence unless there's evidence of intentional destruction. So in a recent case that's currently under appeal, an employee who left to go work for a competing company, and there are allegations of theft of corporate opportunity, he was under an order, subject to an order to preserve documents. And the day before his computer was to be produced, he used a document cleansing software to cleanse his browser history and to eliminate I'm not sure what, although his explanation to the court was that he had surfed personal websites and didn't want to be embarrassed. The court ultimately accepted his explanation and did not make a finding of spoliation of evidence. As I mentioned, that decision's under appeal, and I don't want you to take from that's acceptable conduct. I'm only noting it because the standard in Canada is still reasonably high. That said, there are other reasons to ensure your documents are preserved, including that you want your documents available as important evidence in a proceeding. Having notes of contemporaneous discussions or earlier drafts of documents with notes that provide context can be very compelling evidence in proceedings. So as a company, you're going to want to make sure that that evidence is available to prove or defend a case. So once you're satisfied that the obligation to preserve document has been triggered, what do you do? So there's a couple of steps that you're going to want to take immediately. And the first is to ensure that no documents are destroyed. And electronic documents can be altered or modified, even inadvertently, by changing of metadata if a document is accessed and saved over. So working with your very good friends in the IT department, no doubt, steps can be taken to potentially forensically image a computer at that time, or take other measures to ensure that the documents are preserved in their form that they exist at that time. You should also take a look at your company's automatic deletion. Some companies have retain emails for a fixed period of time, and then they're automatically deleted or archived. And you're going to want to make sure, in the context of litigation, that those automatic destruction procedures are halted. There is a rule you should be aware of. Both the Ontario and BC courts have had issued recent rulings that require companies to maintain document retention policies that at least would ensure documents are maintained for over a limitation period for the commencement of a claim, so several years. I suspect most of your policies extend far beyond that, but it's something to just be mindful and aware of, and you may want to go back and take a look at your company policies if you're not familiar with them. So the next step you're going to want to take a look at is litigation hold memo. And that's a communication that is typically circulated to all employees with potentially relevant documents, reminding them or making them aware of the litigation or arbitration proceedings, and ensuring that they themselves take steps to identify potentially relevant documents where those relevant documents may exist. It's beyond just a work computer. It could extend to a home computer, could extend to hard copy files, it could extend to your iPhone, your Blackberry messages, and it's important that these decisions are not left to an individual employee's discretion, but it should be overseen. Often you, in your role as in-house counsel, would oversee that process, working with your external counsel, working with IT, and sometimes even working at an early stage with a third-party document management provider who can provide guidance on steps that should be taken to ensure those documents are segregated and available for later in the process when the production becomes necessary. So the litigation hold memo should be circulated to anyone who may have documents that are relevant, and that extends to assistants, it extends to practice groups like accounting or other departments that might have potentially relevant records. Just a couple of stories you may find of interest. I'm sure many of you are familiar with a case a number of years back involving a group of senior employees who left en masse to to start up a competing operation. And in the context of that litigation, some of the most publicized productions came from Blackberry to Blackberry messaging, and that sort of dates our case because we're talking about the Blackberry messages, I think BBM or pins, and I'm pretty sure that those individuals were communicating in that method on the assumption that those communications would never see the light of day. But ultimately, they did go through the company server, they were produced, and they were quite compelling evidence in the proceeding of evidence of their intention and conspiracy efforts in leaving the company. And another perhaps more relevant example to today is instant messaging. I'm not sure how many of you use instant messaging, but in a case that I was recently involved in, concurrent with a very important discussion that was taking place between third parties, a couple of employees were instant messaging each other, making observations about their boss and his demeanor, his personality, and relevant to the discussion that was taking place. And because that discussion itself was so pivotal to the litigation, those instant messages got produced and were the subject of discovery, I'm sure to the embarrassment of those who wrote it. So a word of caution that you can share with your employees or implement personally. But really, the message is everything is potentially producible. Even Snapchat messages that my children think disappear instantly are retrievable in some ways, not always, but they're, nothing's ever gone. So just take that as a word of caution and tell your children. Remember that your obligation to preserve documents is broader than the ultimate obligation to produce. So the net that you're going to cast at an early stage is quite broad. And just turning this on its heels for a moment, it's really good practice to demand that your opponents circulate a litigation hold to ensure that the other side is similarly preserving documents. And their failure to do so can actually be if they don't do so, it can be quite helpful. I regularly, during a discovery, will ask my opposing party for a copy of their litigation hold memo. That will tell me information about the date they issued their litigation hold, the custodians that they issued it to, and if they in fact didn't put a litigation hold in place, I can get a little more leeway asking questions about their document collection efforts. And if there's a gap in the productions, I find that the courts are more willing to allow me to make further document demands if they haven't shown signs of putting in place a good litigation hold and document preservation effort from an early stage. So this segues to my next topic, which is document collection. And I'll just touch briefly on this and on the next topic. Once active litigation or arbitration proceedings are underway, the parties have an obligation, it's a requirement, to meet and discuss a documentary discovery plan. And it's supposed to be put in writing. And again, like Tamron says, it's better to negotiate these things up front rather than fight about them at the end. So if you can agree on the scope of the productions, on the date range of appropriate productions, on keywords that should be searched, on custodians, topics to be covered, that can really be quite helpful both in guiding your own document collection process and also in ensuring that you're getting appropriate production from your opposing party. Because a lot of the documents that you've preserved will be not relevant, they have to be collected so that they can ultimately be reviewed to identify documents that are relevant and not privileged. So this is a role as in-house counsel that you'll often play, working with your IT team, working again with your external counsel, and we find it very helpful to work with external third-party document managers who have a lot of experience in this area. Documents are collected, they're scanned electronically, they're objectively coded to capture the author, the recipient, the date, and then the fun part starts for us lawyers, which is the document review and production exercise. So for corporate lawyers in the room, this is comparable to due diligence. It's our litigation document review, and we can either review documents individually, one by one, or you can review them by using key search terms to narrow lists of potentially relevant documents. And ultimately, what we are trying to identify is documents that are relevant as opposed to not relevant, and documents that are not privileged. Privileged documents do still have to be listed and identified, and privilege logs of documents that have been withheld based on privilege do sometimes have to be shared with opposing parties. And I know you all know this, but share with your employees, just copying in-house counsel on an email does not automatically make it privileged. It's amazing that we're still having those discussions, but I'm sure there's people who think if I just CC my lawyer, it's an automatically privileged document, and I know you all are aware that that's not the case. The obligation to produce documents exists if they're relevant. It doesn't matter if they're harmful or helpful or sensitive. All documents have to be produced. Again, if I can leave you with one message from this presentation today, It is to document every step that you take concurrent with taking it. So if you are identifying custodians, if you're identifying search words, if you are using date ranges, whatever, step by step, someone, and it will often be the in-house counsel, should be maintaining a concurrent memo documenting all of the steps that have been taken for document collection, because I assure you it is much easier to do it at the time than to try to recreate those efforts 5 years later. And I'm just going to leave you with one final story because it was a headline that someone brought to my attention from a newspaper article in January, so you can go and look it up. It really is true. The headline is, hold on, I got to read the actual headline. It says, how Volkswagen's in-house lawyers screwed up a litigation hold. So a headline you never want to read about your own company. So it took place in the U.S. There were obstruction of justice charges filed against Volkswagen's in-house counsel, who apparently tipped off their employees that a litigation hold was about to come the next day and advised them to destroy documents and data and a hard drive containing emissions control information before the litigation hold was circulated. So that is a bad practice. And incidentally, those documents were recovered, so nothing was ultimately achieved. So that concludes my presentation. If anyone has any questions about this very exciting topic, I'd be happy to field them. Shockingly, none. I'm going to turn this over to Hannah.
Okay, thank you, Susie. So now that you've completed your document preservation and collection, as Susie just described, you may discover within that collection documents that your company considers confidential or that contain confidential information. This might include your company's sensitive financial data, for example, or confidential information relating to third parties such as customer contact information, medical records, etc. And just to expand a bit further on what Susie was speaking about, whether or not a document is confidential or contains confidential information is irrelevant to the production. As Susie said, the general rule of thumb is that all relevant, non-privileged documents have to be produced. So even if it contains confidential information, that's not a reason to hold it back. And also, in addition to the company's affidavit of documents, there may be other times where, during the course of a litigation, you have to produce confidential documents or refer to confidential information. Examples include affidavits that you might file in support of a motion or in response to a motion, or information that may come out during a cross-examination. So understandably, you might be concerned about this confidential information not only being provided to the other side of the dispute, but also possibly being filed in a court record and being accessible to the public and the media. So this morning I'm going to be speaking briefly about some of the protections that are available to protect your confidential information and some steps that you can take to try to get some further protection, including trying to get a sealing order. The rules of civil procedure, which apply to civil disputes in the province of Ontario, provide some basic confidentiality protection for parties' documents and information. The rules include what is referred to as the deemed undertaking rule, and this rule provides that parties and their counsel are deemed to undertake not to use evidence obtained through certain limited channels, specifically through the discovery process, which includes affidavits of documents or examinations for discovery, for any purpose other than the proceeding in which the documents or information were produced. The deemed undertaking rule, however, does not apply to other channels where this confidential information may come out, including the affidavits and cross-examinations that I referred to earlier. It's also subject to some exceptions, including that once a document is filed in the public record or information is referred to during a court hearing, the deemed undertaking rule no longer applies, and that information can then be used by the other party for basically any purpose. And when we're speaking about trying to get confidentiality protection in the context of civil litigation, we have to remember that proceedings in Ontario are governed by the open court principle. This requires that court proceedings in the province be open and accessible to the public and to the media. Also, once documents are filed with the court, they become part of the public record and can be accessed by basically anyone who wants to go to the court office. They can look at the documents and even take copies of them. So this This may raise some concerns. You don't always want that information being so available, but any efforts that you want to take to limit that accessibility are going to have to be viewed in light of the open court principle. And actually, just today I was reading a piece in the Toronto Star where apparently yesterday the Star commenced an application challenging some of the restrictions it's encountered in trying to get access to information contained in files at administrative tribunals. So administrative tribunals include, for example, the Human Rights Tribunal, the Landlord and Tenant Tribunal, those types of places where apparently the Star says it's been having more difficulty getting access to documents, and that there's been sort of patchy compliance with providing information they've requested, and often they've been told to make a Freedom of Information Act request, which they say is not reasonable. So we'll wait to see what happens with that application. Also, just tying back into what Tamron was speaking about earlier, the types of disputes and the types of documents that you anticipate having to produce may be something that you want to consider when either drafting an arbitration clause to be included in an agreement or deciding whether you want to arbitrate versus litigate. Because if you're in an arbitration process as opposed to the Superior Court of Justice, you're going to have a bit more control over how far your documents go and who gets to see them. So there is a type of order available that you can try to seek from the court to seal a portion of a court file. These are referred to as sealing orders or often confidentiality orders. These type of orders can be given to either protect your company's own information, for example, your financial information, trade secrets, that sort of thing, or they can be given to protect confidential information relating to third parties that you have in your possession. Section 137 of the Courts of Justice Act provides the court with the authority to seal a portion of the court record, and the court can order that a document can be treated as confidential, sealed, and not form part of the public record. However, these types of orders have been described as being extraordinary and as being granted very sparingly. While the authority to grant a sealing order is provided for under the legislation, the test that's actually applied by the court has been developed through the jurisprudence. The leading case on sealing orders is a 2002 decision of the Supreme Court of Canada in the Sierra Club case. In that case, the court considered when and under what circumstances a confidentiality order should be granted. This case was actually decided under the equivalent federal court rules, but subsequent cases have confirmed that it is the same test is to be applied in Ontario. The moving party in Sierra Club was seeking a confidentiality order over some technical information about an environmental site assessment in China relating to the construction of nuclear reactors. The documents that the moving party was seeking to seal actually were the property of the Chinese authority and had been provided to the party on the condition that they would be subject to a sealing order. So the Supreme Court of Canada in this case set out a two-part test, which if you are a lawyer and you went to law school, will take you back to your first year constitutional law case class. It's a two-part test. In the first part of the test, the party must establish that the order is necessary, which includes establishing that there is a serious risk to an important commercial interest, an important interest which can include a commercial interest, because reasonable alternative measures will not prevent the risk. And I've just put this up on the slide because there's quite a few elements even within that first branch, and I'll just speak about them briefly. So some of the considerations that the Supreme Court said should be looked at under the first branch include whether the risk being described is real and substantial and is well grounded in the evidence. Also on whether or not an interest can constitute an important interest, the court said that the interest shouldn't be merely specific to the party seeking the confidentiality order. It should be able to be expressed more broadly in terms of a public interest in confidentiality. So, as for examples, the court in this case gave an example where, for example, the agreement that you're trying to get a sealing order over is with a third party and it contains a confidentiality clause. Other examples include protecting third-party financial information or settlement privilege. And finally, the last element under the first branch is whether there are reasonable alternatives to a sealing order. This could include redacting the information you're concerned about, possibly, or filing a summary of the document rather than the document itself. Next, assuming you meet the first branch of the test and establish that the order is necessary, the court then moves on to a cost-benefit analysis and will weigh the benefits of granting the order versus the costs of granting the order. The costs obviously include the effect on the open court principle and the public's access to the court records. And you should also keep in mind that generally when we're talking about sealing orders, we're not talking about an order that's going to prevent the other side to your dispute from viewing the document or information. However, there is a subset, a tweak on a sealing order that we refer to as counsel's eyes only orders, where not only will the public or the media be excluded from seeing this information, but actually the party itself. So in some cases, the court may grant an order where only the lawyers for the parties can view the information, or maybe the experts that the parties retain, but not the parties themselves. Or the court might limit the number of people at the other side who can view it. So maybe it's 3 people can view this information, and they have to sign something saying they won't distribute it further. These types of orders are even more rare and tend to be granted in cases where the parties to the dispute are competitors, and disclosing the document or information could give the other side an unfair advantage. So in terms of the practicalities of actually getting a sealing order, you have to bring a motion to the court. The motion should ideally include some affidavit evidence touching on the tests set out in Sierra Club, including why you're concerned about this information, what's the risk if it gets out into the public realm, and why alternatives would not be sufficient to protect that information. Even if the other party to your dispute consents to the order, that's not a guarantee that the court will grant it, because, as I mentioned, the court's concerned about this broader public interest in having an open court system. However, the consent of the other party is likely to be a consideration that the court will take into account when hearing your motion. Also, while the courts generally always apply the Sierra test, the scrutiny applied to motions does vary based on the dispute, the type of document or information we're talking about, and whether there is media or public interest in your case. So part of the exercise when considering whether or not to try to get a sealing order and what you're going to need to give to the court is looking at those factors, saying, how much opposition do I expect to get here? Are there bigger considerations here that the court's going to be concerned about? Like, is this a case that the public's going to be interested in, or the media is going to want access to? And also keep in mind when we're reading the cases, reported decisions about sealing orders, these are often cases where the sealing order has either been opposed by the other side, or where there's the media has intervened in saying that they oppose this order. So, those cases, often the test is set quite high. As I mentioned under Sierra Club, one of the things you need to address in your motion is whether there are alternatives to the sealing order. And these are also things you might want to consider even before you bring your motion, just because they might be more cost-effective and efficient. One option is a confidentiality agreement. So when you're collecting and producing your documents, there may be documents in there that you're worried about getting out into the public. But in reality, those documents may not be important at the end of the day and may never get filed in a public record. So bringing a motion for a sealing order may be premature. And what you might want to do is consider an agreement with the other side, which may work better if they also have documents they're concerned about, where you agree that if you intend on relying on one of their enumerated confidential documents, you'll give them notice, let's say 10, 30 days notice before you file it with the court, in order to allow them an opportunity to bring a motion for a sealing order. And that way, if the documents don't end up being important in the litigation, you're not wasting your time getting a sealing order unnecessarily. Another alternative to a sealing order is redactions. This tends to only work if you're redacting irrelevant information from an otherwise relevant document. And the general rule is that if a document's being produced, it should be produced in its entirety, unredacted, but there are certain exceptions that have been allowed, including redacting irrelevant information that might be sensitive, including patents or trade secrets, sensitive financial information, or records of a purely private nature like diary entries. Like if you, for example, if you're producing your diary, there are entries there about meetings you had with third parties or people internally, but there's also your appointments with your doctor. It may be permissible to redact your personal appointments from those records. However, that would be possibly subject to a challenge from the other side if they're not allowed to vet that themselves. So in conclusion, while it is possible to obtain some protection of your confidential documents and information in the civil litigation process, there are no guarantees. And requests for confidentiality orders are going to be weighed with the public interest in having open and accessible courts. And this is also a factor that you may want to consider when you're drafting your arbitration clauses and considering whether to litigate or to arbitrate. I'm happy to take any questions. Okay, I will pass it on to Brad Halfin, who's going to be speaking about settlements.
Thanks very much, Hannah. So you've all likely heard the statistic that about 95% of all civil cases will settle. What you probably haven't heard is, or what's not published, are the costs that all the parties have to incur in order to reach that settlement. At the same time, you've probably also heard the saying that a good settlement is where all the parties walk away unhappy. And from some of the smiles and nods in the room, I see that you've either heard that saying or have been part of an unhappy settlement. So with settlements being such a likely result, it's critically important for parties to start thinking at the outset about the strengths and weaknesses of their case, and to think about the strategic ways to find a way to resolve a case at the earliest possible time. Settlement obviously involves a degree of compromise, and there are obviously costs to everything in the litigation process, including settlement. But my goal for the next 15 minutes or so are to speak about some tips and strategies so you can hopefully maximize the value of your next settlement. Not that I'm wishing litigation on any of you. So I'm going to hit on three main topics. Why is it that the majority of cases settle? Some timing considerations, and actually finalizing a settlement. So why is it that the majority of cases settle? And there are three main reasons: control, finality, and costs. So control. In a settlement, you maintain control of the process. Once the court renders a decision, it's out of your hands. Controlling the process also means that you can be creative about the settlement. You could craft something that the court may not be able to provide. For example, we acted once in a long-term lease dispute where there was an issue with a club who was operating on site who wasn't able to maintain their membership numbers. And there was a dispute about whether or not the lease could be terminated. And we ended up agreeing to a settlement whereby we agreed to reduce the number of years remaining on the lease, and the club was allowed to stay. So it was a settlement where actually both parties walked away happy, and something that the court wouldn't necessarily have been able to provide. So with that in mind, think about something that you may be able to provide to the other side that the court may not be able to grant. Something other than a dollars and cents settlement which may benefit both parties. Similarly, just because you may or the other side may have deeper pockets doesn't necessarily determine who has the better bargaining position. There may be other things to consider such as reputational interest, which may offset the deeper pockets. Secondly, settlements offer finality. Once a settlement's in place, you no longer have to worry about legal bills. You don't have to worry about how long the process is going to take or if the matter is going to be appealed. Trials, on the other hand, are uncertain. The biggest risk factor, you have no idea what the judge or arbitrator is going to decide. You can put your best case forward and still not achieve your desired result. Many lawyers will tell you, including me, that they've won cases they should have lost and lost cases that they should have won. While this may balance out for the lawyer, you necessarily don't want to be on the other side of that spectrum. Trials are also expensive. They can take years, they can get bogged down in a number of motions, and there is such a thing as litigation fatigue. A number of years down the road, many clients will take a settlement which they're not otherwise happy with because they're just tired of the fight and tired of the escalating legal bills. Really, the question you have to ask yourself is how much money are you prepared to spend over the course of a litigation? At the start of a litigation, I've heard clients tell me that they'd rather pay me as opposed to paying 1 cent to the other side. And I tell those clients that they're my favorite. But in all seriousness, many times parties are prepared to pay a slightly greater amount than they otherwise would in order to ensure finality, to reduce the cost, and to achieve a final end to the litigation. Not only do you have to consider the factors that are associated with what happens if you lose, you'll have to pay your costs plus the costs of the other side, but what are the costs associated with winning? You may go down a legal fight that may take 5 years and spend a significant sum of money, only to achieve a judgment which may only equal the amount of costs that you spent. At the same time, what are your personnel costs? How many people do you have working on the litigation? How many people are answering lawyers' questions, collecting documents, or taking a valuable time out of their day to deal with the litigation? So with that being said, I want to chat a bit about some timing considerations. Now, obviously, the best time to settle would be right away, but that doesn't necessarily happen with all cases. And most of the time, in a heated and sometimes emotional dispute, parties aren't always objective about what they want and how to get it. So one of the most important points that I can stress is from the outset, be open, honest, and objective about the likely success or failure of your case. Like I said, some people walk into a litigation and say, I'm not paying a cent, or I'm refusing to accept anything less than the full value of my claim. While that's not necessarily achievable as a perfect result, that doesn't mean you shouldn't aim to achieve a smart result. So what does that mean? It means analyze the strengths and weaknesses of your case, both from a factual and legal perspective. What facts or documents do you have that will help you? What facts or documents does the other side have that may hurt you? Where do you stand from a legal perspective? Analyzing these facts from the outset will assist you in making an informed decision, set your expectations, and let you start thinking about what a rational, achievable outcome may be. Similarly, the early informed settlement discussions can take place, the better chance you have will be to settle. There are many occasions where costs become a barrier to settlement, and parties are down the road and feeling they have no alternative but to proceed to trial because of the amount they've already spent. So, how can you try to position yourself to settle at the earliest possible opportunity while saving the most amount of money or, at the same time, maximizing the amount you'd get on a return if you did win? Your lawyer's going to tell you about Rule 49, or in the federal court, I understand, Rule 420. These are rules that are designed to encourage parties to settle by imposing cost consequences by rejecting reasonable offers to settle. I'm not going to get into the major technical elements of the rule, but generally, if you make an offer to settle and you beat that offer at trial, you're going to be entitled to a greater scale of cost than you otherwise would be. It creates a real incentive to make serious offers to settle and to take offers that you receive seriously. So how can you take advantage of the rule? You can make an offer to settle at any point in time, at any stage in the litigation. And a lot of these times happen at key stages in the litigation or just before parties are about to incur significant costs. So for example, as Susie mentioned, right before you're about to start collecting and producing documents and going through the document review procedure, which can be quite expensive, many times party will put out an offer to settle so that if they are successful, they can get a greater scale of cost than they otherwise would. Similarly, prior to examinations for discovery, and after the exchange of expert reports on damages when parties have a better idea about what the actual damages may be in the trial. Another way to use offers is as a negotiating tool. So for example, you can stage an offer. So you can have an amount of money that you'd be able to pay to a certain point of time, and after that, the expiry of that period of time, if you're a plaintiff, you'd say, I'd only be prepared to take more than that, or as a defendant prepared to pay less than that. A couple of key technical points about Rule 49. The onus is on you to show you've beaten your that you've beaten your offer at trial. What does this mean? This means that if it's simply a dollars and cents offer, it's pretty easy to show whether or not you've beaten that amount. But if you're including other terms in your offer, such as non-monetary terms, it's a little more difficult to prove whether or not you've beaten your offer. If you're making an offer to settle, it has to be made at least 7 days before trial, and it has to be open until after the commencement of trial. There is case law which says that an offer to settle, which expired 1 minute before the trial started, didn't attract the cost consequences under the rules. Importantly, because the offer to settle has to remain open, it can always be accepted. So even if you put an offer out there and the other side either rejects it or puts forward some counteroffers, it can still be accepted later on down the road unless it's withdrawn. So if you have an offer to settle out there and you want it withdrawn, make sure you do so. That being said, I've spoken a little bit about Rule 49, but you don't necessarily have to make an offer to settle that complies with that rule. You can make general offers to settle at any point in time, and judges do have discretion in awarding costs, so they will consider those offers. Make sure you seize the opportunity. Mediation is a very important feature of our litigation system, and many times litigation will not settle at mediation. And there's no harm in walking away at mediation if the parties don't settle, or if the deal isn't right. But the further along settlement discussions are, the harder and harder it is to get back into a litigation frame of mind. Take advantage from the momentum, even from a failed mediation. I was involved in a recent case where the parties didn't settle at mediation, swore that they'd go to trial, and settled 2 days later. That being said, there's nothing that restricts you from the procedures that are set out in the rules. If you have a good handle on the documents, or if you have a good handle on your case, you can propose settlement negotiations at any time, propose a mediation at early time to try to get the parties to the table. So, at the end of the day, how do you maximize value? Speak to your lawyer about the best times to make an offer to settle and the value of that offer to settle. Take into account more than just the number on the page. What's the cost to you of the litigation forward, both in terms of actual dollars and the value to your personnel? And what's the present value of the money you're either prepared to take today or prepared to pay, as opposed to later on down the road? I want to speak briefly about finalizing the settlement. It's very important to separate when a settlement has been reached from when a settlement has been concluded. And a settlement agreement is a contract, and so basic principles of offer and acceptance apply. The terms of an offer must be matched exactly by the terms of an acceptance for there to be a deal. And in most settlements, it's extremely common that deals are struck before documentation can be complete. In those cases, assuming there has been clear offer and acceptance, there still is a binding contract, notwithstanding that the documents haven't been executed. That being said, you can still agree that any deal you make is tentative and not final and binding until the documentation is actually signed. So make sure you're clear about what exactly it is that you're agreeing to. If there has been an agreement where documentation is to follow, you can put forward whatever documentation you want without rescinding the agreement. Negotiation about documents can and does continue, but neither party is discharged from their obligations to the settlement until someone has expressed a willingness not to be bound. And in those cases, if you're the other side and you still want to enforce that settlement, you can apply to the court to do so. I want to speak very briefly now about actually documenting the settlement. Be clear and precise. How is each stage of the settlement going to occur? Who is responsible for completing each step? Who is responsible for taking out the order? Are there specific terms you may want in a release, such as a confidentiality clause, a non-disparagement clause? Are settlement funds going to be held in escrow? If so, who is going to be acting as the escrow agent, and what are the terms that are going to be necessary to have the funds released from escrow? The most important point about this that I can stress is how objective are your terms, what I like to call, can the parties check the box? Many times, settlements simply involve the exchange of money for a release and a dismissal of the action. In other cases, you may have to provide certain documents or provide evidence that something's been done. In those cases, include dates, names, titles, etc., so that it's very clear and objective about what it is that you're actually agreeing to, and so that there's a measure by which the parties can agree that a step has been done. Try to avoid those ambiguities, which can lead to further fights down the road, further costs, and fights about whether a party has complied with their obligations. So, in summary, make sure you understand the strengths and weaknesses of your case at the earliest possible stage so you can make an informed and rational decision and set your expectations. Know that there are cost consequences associated with refusing to accept a reasonable offer to settle, and make sure the terms of your settlement are clear and can be objectively accomplished. I'm happy to take any questions before passing over to Mark.
What are the kind of terms that could hurt you in an argument on costs? I think a lot of people now are asking for a release to be agreed upon. or actually attaching a full-blown release? How do you argue that you've beaten that at trial when the court can't order a release?
If the release is something that you propose as part of your offer to settle, that's one of those non-monetary terms which are very difficult to prove to the court that you've beaten. And so the court will look at that, and it's very difficult to say, well, here's my release, they didn't agree to it, or they did agree to it. It's hard to prove that you've beaten your offer. Okay. Oh, yeah.
Just wondering how realistic it is for you as counsel to somebody to provide them with a settlement range prior to discovery.
So the question was, how realistic is it as counsel to provide a settlement range prior to discovery? Question? Yeah. And the answer to that is it's, very fact specific. It depends on the documents that you have, how many, on the scale of document production. If your data set is something like 900,000 documents, it's going to be very difficult to provide a real settlement range before discoveries. If that document set is much smaller, you're more likely to have a better idea about what your costs are. It also depends on the value of the claim. If it's a $100 million claim, it's probably more difficult to provide a real settlement range as opposed to whether or not the claim is in the hundreds of thousands or the lower millions. Okay.
So my name's Mark Dunn, and I'll be speaking to you about the enforcement of orders and judgment. And what that means at a very high level is the process of taking a legal right that's been vindicated through the litigation process that we've just talked about and turning it into a practical reality. And this is obviously something that comes at the end of a case, but it's also the most important step, and it's something that needs to drive thinking throughout. As any football fans in the room learned on Sunday, endings matter a lot. And the ending of litigation matters a lot. No matter how great of a job is done in obtaining an order, the strategic decisions at every stage need to be driven by whether that order is going to be enforceable and whether it's going to accomplish the goal. And so one question that should be asked at the outset of every case, and is not always asked at the outset of every case, is your first loss your best loss? Is the right answer to do nothing? And the reason why I say that is because if there are no assets available to satisfy a judgment, then pursuing the case will simply increase the losses that you're trying to recover. Now, that's not to say that there's not valid non-economic reasons to sue. And sometimes a reasonable and thoughtful decision can be taken to pursue a result that may not be fully recoverable. Employee fraud cases are one type of case where I've seen that decision taken, where an employer is very hesitant to let an employee be allowed to keep ill-gotten gains. But suing to vindicate a principle is a very expensive way and frequently unsatisfying way to accomplish that goal. So in almost every case, the key question is whether a legal victory can be translated into a practical victory. So most lawsuits seek a money judgment. And I'm going to spend most of the time today talking about how to enforce money judgments. The process for enforcing a monetary judgment and a non-monetary judgment are very different, and you have very different options and sanctions. And I'm going to touch on non-monetary judgments a bit at the end. So at a very high level, when we're talking about satisfying a money judgment, if it's not paid by the defendant, there are 3 steps. You have to find assets, you have to seize assets, and you have to sell the assets. And in a perfect world, by the time you get judgment, which could be many years after a dispute arises, you should have some idea about what assets are available to satisfy the judgment and where those assets are located. But as a general rule, a litigant doesn't have the right to inquire into their opponent's assets until after judgment. It's not an absolute rule, but the discovery process in litigation doesn't extend to the assets of the opponent generally. So that's not to say that there are not other methods of gathering information pre-judgment about the assets. Many individuals and companies put a lot of information about themselves online. Never underestimate people's capacity to publish information that's harmful to their interests and contrary to what they're saying in litigation. So my favorite example of this is the rapper 50 Cent, who filed for bankruptcy to avoid a couple of judgments that went against him in litigation. Now, of course, bankruptcy proceedings require disclosure of all of the assets and proof that the debtor is impecunious. So while subject to bankruptcy proceedings, 50 Cent saw fit to post pictures of himself literally lounging on a bed of cash, which you'll see here. Now, this was immediately, there's a postscript to this, which is that this was immediately brought to the judge's attention. He was hauled into court to explain himself, claimed that this cash was rented and not his cash, which is a business I was unaware of. And then several months later, essentially did the same thing again. So now, it's unlikely that your opponent is going to do this, but people publish a lot of information about themselves, and people claiming in litigation or after judgment to be impecunious may very well be posting on social media or otherwise information that is not consistent with that. Other ways to learn about assets is there's a real property register in the 20 or so land titles offices in Ontario, and those can be searched relatively quickly and inexpensively, which will tell you if somebody has real estate in Ontario. There are similar processes available in other provinces, and that'll tell you if somebody owns land and what mortgages are registered against it. So that'll give you some sense. You can do an execution search, which will tell you whether judgments have already been registered in courts against that person. Obviously, suing somebody who already has several unpaid executions registered against them is something that some thought needs to be put into. Private investigators can be helpful in the right circumstances as well to follow the subject, search records that they have access to, and take other steps. After judgment, the situation in terms of entitlement to information changes very dramatically. A judgment creditor, that's a person who has a judgment in hand, is entitled to essentially all information about the assets of the judgment debtor that are available or might be available to satisfy a judgment. The legal mechanism for determining this is called a judgment debtor examination, which can be done once a year as long as the judgment remains outstanding. It's very broad in scope. Any question that can identify assets has to be answered. Failure to attend or provide necessary information can result in contempt charges. The big weakness with the judgment debtor exam is that judgment debtors as a whole are not known for their honesty. That's not to say all are dishonest. Many are very honest and simply impecunious. But unless you have some other source of information about the debtor's assets, to compare what you're being told to, even if it's limited, whether it be from social media or a private investigator or real property search. It can be very difficult to identify answers that you're getting that are untruthful. So once you've identified assets, the assets then need to be seized. The person in Ontario who's responsible for seizing the assets is called the sheriff. This is not the sheriff that you have in mind when I say the sheriff. There will be no posses and no horses involved. In fact, the sheriff will do virtually nothing that it is not specifically directed to do. So the process for directing the sheriff to seize property is administrative. It, in almost every case, does not require an attendance before a judge. You can file a writ of seizure and sale in the county where the property is located, and that needs to say exactly what the property is and exactly where the property is, and the sheriff needs to be directed to seize exactly a very specific item. So, and that specific item can be the most commonly seized assets are bank accounts, real estates, valuable paintings, jewelry, but the universe of assets that can be seized is not limited. In fact, in researching this presentation, I learned that there is a show on the Discovery Channel about a gentleman who claims to be one of America's premier exotic animal repossessors, which of course implies that there's many exotic animal repossessors in business, and that this gentleman is, for whatever reason, among the premier ones. So, if your defendant happens to own a tiger, you can seize it, and the sheriff can sell it. So, a better question than what can be seized is what can't be seized. So you can't take the shirt off the debtor's back, literally or figuratively. A judgment debtor is entitled to keep clothes of up to $5,600 in value, furniture of up to $11,300 in value, and a car as long as it's not worth $5,650 in value. So people are left with some basics. You also can't seize welfare payments, insurance payments, pension benefits, CPP, EI. But subject to those and a couple of other slightly less common exemptions, all of the debtor's assets are available. The final step in the process is to sell it, and the sheriff is responsible for selling the property. That might not be ideal, particularly if the assets are being seized from a competitor, and you might have a superior ability to sell the property, but as a general rule, that's what happens. The other thing to keep in mind from a sale of seized assets is that the proceeds are distributed equally among all creditors. So it's not a race to get your hands on the assets. In the absence of some sort of security or priority, the sheriff seizes and divides the proceeds among all the creditors, not only the one who directed seizure and sale. So that's the process for seizing assets, and that includes money assets. For this purpose, a bank is a bank account, and the money in it are assets. There's an alternative procedure for debts that are owed to the judgment debtor, and that's called garnishment. And it's essentially the process of intercepting debts that a third party owes to your judgment debtor. The most common example of this is employment wages. You can send a notice of garnishment to the judgment debtor's employer, who is obliged to remit a specified percentage of the wages to you. This is very commonly done by the CRA, and some of you may have received those notices. So in the time that remains, I'm going to spend 1 minute talking about obstacles to enforcement that can arise, and 1 minute talking about how to enforce non-monetary orders. So the first obstacle to enforcement that I'm going to talk about, and one of the more likely ones to encounter, is where assets are held outside of the country, especially where a debtor is based elsewhere and has insufficient assets in Canada to satisfy the judgment. So the question of can I enforce this judgment in such and such country is a complicated one. It varies depending on the specific country and jurisdiction that we're talking about. As a general rule, your ability to enforce in a country is tied to the strength of the rule of law in that country. So if the country has a functioning court system and rules that are similar to our own, then your ability to enforce will generally be good. In other countries, examples that I've dealt with are Russia and China. Your odds are less good. So the other issue that often arises is whether the debtor intentionally divests himself or herself or itself of assets in an attempt to defend against the judgment. Transactions entered into for the intent of defeating and defrauding creditors can be set aside. If the company is if your debtor is a company, an oppression remedy is a potential avenue for having those set aside or getting other relief. And okay, so turning to the final piece of this, because I've just run out of time, so I'll be very quick, which is how to enforce a non-monetary order. And the answer to that is with a contempt motion. And if you prove that a person is in contempt of an order, that does not include an order that requires the payment of money, and you can prove that beyond a reasonable doubt, then a broad range of penalties are available, including fines and jail time, and the jail time can be meaningful. So the contempt power is a very powerful tool, both at the end of the litigation process, if you've obtained an order for specific performance or an injunction or something of that nature, and during the litigation process to address a refusal to comply with the party's obligations. So that concludes my presentations. My presentation in terms of your broad options in terms of enforcing orders and ensuring compliance once you have succeeded. And on behalf of the panel and everyone here at Goodman's, we'd like to thank you for joining us this morning, especially in the less than ideal weather situation. Neither rain nor sleet nor snow will prevent CPD hours from being obtained. I'd like to thank Rebecca Olsher and Carly Fox, two associates who were instrumental in putting this together, as well as Sandra Montanino, our CLE director, who was and is always instrumental to putting these presentations together, as well as our partner Peter Ruby, who provided us with a lot of sage advice and guidance in preparing this session. We hope to see you at our next Goodman's Presents program, which is by Peter Ruby, and relates to commercial cases that could impact your IT practice, or another event soon. So, subject to any questions on this presentation or any other presentation, thanks a lot for coming.